This is Michael Popok, Legal AF. I want to pick up the pieces about the obstruction of an official proceeding count that some reports are claiming is on life support, and that the Department of Justice will be unable to use either against Donald Trump or against existing Jan 6 defendants who are being prosecuted, or those that were prosecuted in the past, convicted, and maybe even sentenced for obstruction of an official proceeding. I don't believe that's true. In fact, the Department of Justice has now, because they're appearing in court almost daily on some of these Jan 6 defendant cases, they're informing federal judges that they believe that there is still a path, as narrow as it may be, to continue to use obstruction of an official proceeding against Jan 6 insurrectionists. And I'll do a separate part of later in this hot take about why Donald Trump is going to have his obstruction of an official proceeding stay in his indictment through Judge Chutkan, even under this ruling. Let me back up for a minute for those that are sort of joining this a little bit later about the ruling, and then we'll go forward from there. In Fischer versus the United States, a Jan 6 defendant claimed that he could not be convicted or charged with an obstruction of an official proceeding because that 2002 federal statute came out of the financial crime world and had to do with the destruction of physical documents, tangible evidence, to prevent in this case, an investigation into the wrongdoing of a company. It was called Enron at the time, and the entity that was caught with its hand in the cookie jar destroying documents was a well-established 100-year-old auditing and accounting firm then called Arthur Andersen. And it had to do with that. But the language of 1512C1 and 2, 18 U.S.C. 15C1 and 2, which are the subparts of the statute, they on their face, and this was the argument, go beyond physical destruction of documents and go on to other ways that a proceeding can be impaired, right? And that's the focus. And what was the door that was left wide open by the Supreme Court decision, which ruled that unless there is an impairment or destruction of physical evidence, of documents, of other types of things, that's what on first blush, there can't be an obstruction of an official proceeding charge. It can't apply. And sent it back to the lower courts to figure out whether in case-by-case circumstances, people like Fischer and the other 350 people charged with this crime meet that new test. But there is a path in the new test, as outlined by Ketanji Brown Jackson in her concurrence, because she joined in the majority on this one, which was if there is the creation of false evidence, which is the fake elector certificates, I posit, and they mentioned it by name in the first 7 or 8 pages of the majority opinion. If fake evidence is used, which impairs the integrity of a process, that counts for obstruction of an official proceeding. So that's why Donald Trump, with the fake elector scheme and the way it was so artfully put into the indictment that was rendered by the grand jury for Jack Smith's special counsel team, that will be used against Donald Trump. You impaired the integrity of a process by using fake evidence, the fake elector certificates. So have a seat, sir. You're not dismissed. On the other Jan 6 defendants, Ketanji Brown Jackson laid out in her concurrence. Now, it's not the majority opinion, but it does give a path. She did join in the majority, in the 6-3 majority. She said, if there is an impairment of the integrity of the process, then that can also count as obstruction of an official proceeding. So you got to look at integrity and impairment when you're doing your analysis. And the argument would be, when you are battling it out medieval style, right, on the steps of the West Portico, the West Terrace of the Capitol, to try to stop and delay the certification of the election, you are impairing the integrity of that process without having gotten your hands on the physical documents. And so what the Department of Justice is smartly doing in court proceedings, they are now having, even since in the last few days, they are telling judges federal judges, they don't see this new decision as destroying their ability to continue to use obstruction of official proceeding against defendants. Let me read to you what they've said in their recent presentations to courts. The prosecutors before Judge Mehta, in a case involving Donovan Crowell, who was a member of the Oath Keepers, said in a filing just right after the ruling by the United States Supreme Court, quote, the Supreme Court did not reject the application of the obstruction law to January 6th. Rather, the court explained that the government must establish that the defendant impaired the availability or integrity for use in an official proceeding of records or attempted to do so. That is straight out of Ketanji Brown Jackson's concurrence. She said in her concurrence, let me just get this right for you. She said in her concurrence, laying out this groundwork, that if you focus on integrity of a process, you may be able to thread the needle and keep that count. In a second Gen 6 case that's already come up before U.S. District Judge Cobb, the prosecutors asked for an indefinite delay, so in order for them to brief Fischer's application to that case. And they've also asked Beryl Howell, who used to be the chief judge in the D.C. Circuit Court, to await further clarification for the obstruction charge before resuming the case involving yet another Jan 6 defendant. What Ketanji Brown Jackson said is that if when lawmakers were tasked with certifying the vote, if they relied on physical records that were impaired by a Jan 6 defendant's conduct, the mob that day, then that prosecution can and should continue and the issue remains available for the lower courts to determine. That is the glide path, right? That is the lights on the runway to land this plane for a successful prosecution, as explained by Ketanji Brown Jackson, who joined the majority in the Fischer case. And I think it's important that we're going to be doing a series of hot takes here about how the Department of Justice had already anticipated getting bad decisions from the United States Supreme Court, and they are ready and have regrouped about how to handle it. For instance, I believe the Department of Justice will go forward, even if it straddles the election and the inauguration, with trying Donald Trump for the crimes that he committed at the time of the last election 4 years ago. And they're not going to say, well, Department of Justice guidelines say that, we're not supposed to be interfering with an election, or we want to be hands off. We want to be hands off when there's an election nearby because it'll be seen as election interference. For crimes that have already been indicted, right? For trials that are already up and running, or close to being, they're not going to rely on that department. That's not the Department of Justice guideline. The Department of Justice guideline is, if you haven't been able to indict at or around the time within 60 or 90 days of an election, back off. But if you already got your indictment and you've just been delayed because of waiting on Supreme Court rulings, fair game. So I think they're going to straddle the Department of Justice. And I think they're going to go full steam ahead if Judge Chuck can get her case up and running in the D.C. election interference case. Same thing here with their reaction, the fast-paced and fast-moving reaction by the Department of Justice to say, hey, we're not walking away from obstruction of an official proceeding. That was rightly charged. And there are many within the 350 who already got that charge against them, who we can thread the needle that's been provided to us by Ketanji Brown Jackson to argue that there's been impairment of the integrity of the process by the conduct. And if that's the case, the charge should stand. Now, fortunately, they also have a couple of backdoor circuit breakers that they built in to make sure that if this thing went awry at the Supreme Court, which they anticipated, they'd have a way to continue to prosecute these people. Most 80% of the defendants have another felony charge against them. Even for the ones that only had that charge against them and they pled to it, their plea deals say, because the prosecution put it in their plea deals, that if there is if that count gets vacated somehow or attacked by the Supreme Court, they're going to be able to re-prosecute them for all crimes, including ones they agreed in the plea deal to walk away from. So the as we would expect from a thoughtful, mature, professional Department of Justice, they're ready for this. This is a multi-round prize fight. It's not over at all. And I wanted to bring it to your attention about how the Department of Justice is facing up to the challenge to keep the counts in place and seeing within the contours of the Fischer decision the way to do it. And I'll explain it to you right here on the MeidasTouch Network and on Legal AF every Wednesday and Saturday at 8 p.m. Eastern Time, where we do it on YouTube, a podcast we call Legal AF. Now you know why. And then on audio podcast platforms of your choice. If you like what I'm doing, leave me a comment and a thumbs up. It helps with the algorithm. It's not ego. It keeps me on the air, keeps this content coming to you. It helps us build our network. Another way to help us build our network is Patreon. For those that are interested in the law and politics intersection, for non-lawyers and lawyers alike, we have a Patreon at patreon.com/legalaf. For entry-level membership of $10 a month, you get exclusive content, exclusive Popok talks, and Ben Mycelis outlines and overviews of the law, civil law, criminal law, constitutional law, the difference between all of these concepts at the constitutional level and otherwise. It's fascinating. You can nerd out on the law. We do it in an informative and entertaining way, and you can join us for that exclusive content. Patreon.com/legalaf. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.